Friends and colleagues, ladies and gentlemen, it is a pleasure to be here in Basel, the city of art, chemicals, medicine, and of course, FC Basel. And it's a pleasure and honor to give this opening lecture of the Basel Winter Arbitration School first edition. I want to thank in particular Professors Anna Petrik and Jari Krivoi for the kind invitation to give this lecture. We'll be talking tonight about digitalization of international arbitration. What is digitalization about? What is it apart from being difficult to pronounce? Somebody once said that one should never start a speech with a definition, but sometimes definitions count. And in the case of digitalization, they quite literally do, they count. The word digit, as you may know, comes from Latin digitus, which means finger or toe. Digitize in this etymological sense means counting numbers by fingers. Even today, digit means any cardinal number up to 10, the number of fingers. So in a sense, fingers were the early computer. Digitalization or digitization in its modern sense means process of converting information into a digital or computer readable form, into a binary code. It means computerization of information, conversion of information into structured data, into zeros and ones. So there's a difference between digitization and digitalization. Digitalization is a broader thing. It means it's something more practical. It means the use of digital technologies to change the way of doing business, the way of working in order to make it more efficient. Digitalization of international arbitration, therefore, means the use of digital technologies as a tool in international arbitration. It's about digitalization of the arbitration process in order to make it more efficient. It is about moving away from paper-based processes to email, electronic submissions, hyperlinking of documents, co-authoring, electronic platforms for filing, storing and accessing information, and video conferences. Digitalization is not about completely replacing classical paper-based processes with digital processes. It is about the blurring of the boundary between them. It's a hybrid. As we see today, we have many participants online, some of you here in person, three-dimensionally. Digitalization is about moving into an environment where it is increasingly more difficult to distinguish between the real and the virtual. Over the last 30 to 40 years, and we now come back to what Robert Jennings said, Sir Robert said 20 years ago. Over the last 30, 40 years, there has been a profound change in the way in which international arbitration is being conducted. Before this period, we lived in the world of typewriters, paper submissions, in-person hearings, a world where telephone conferences were the cutting edge of the information technology. Before telephone conferences, the cutting edge of information technology was paper knives, of course, used to open correspondence from the tribunal. Things began to change in the mid-1980s, and this is what Sir Robert was complaining about. First came the computers, which were initially standalone and merely replaced typewriters. Then came the email, and soon thereafter the internet. Computers were no longer standalone. They were now linked as part of a network, as part of a wider network. But although the use of email in legal work exploded almost immediately within a few years, the internet initially changed international arbitration less than was expected. There was no systemic or systematic transition to online arbitration. Although internet-based electronic platforms were created in the early 2000s, 20 years ago, for filing and storing of submissions, electronic submissions, including by institutions such as the ICC, which was the early mover, they were not really a game changer, and they were not widely used. There were issues of compatibility between different types of systems and software, but there were also functional limitations. The early platforms were static data storages. You could view the data, but there was not much else or much more you could do with the data. The more radical change occurred within the law firms, gradually from bottom up. Over the years, there was a substantial change in the way arbitration lawyers worked. This change started gradually as various types of software, new software, was developed to support the legal services. These included, in particular, dynamic software that allowed lawyers to create links between evidence and submissions and to generate hyperlinked electronic submissions. When an arbitrator receives an hyperlinked electronic submission, he or she has the entire case, the legal argument, the evidence, the documentary evidence, witness statements, expert reports, accessible effectively through the same documents, through the hyperlinks. The arbitrator has literally the entire case at her or his fingertips. So here is where the old digit, the fingers, meet the new digital. Software was also developed that allowed lawyers to co-author submissions, to work on the same submission simultaneously in parallel. This made the preparation of legal submissions massively more efficient than before and massively faster. There was no longer need to circulate the draft from one lawyer to another so that each of them could make a contribution, and for the others then to wait that the work was completed. But these developments did not change fundamentally the way in which arbitration proceedings are conducted. Even if written submissions became digital, hearings continued to be held in person in one location. Online arbitration, in the true sense of this word, is something that has become a reality only over the last couple of years as a result of the pandemic. In other words, it has become more dominant, not by design, but by necessity. The key to the development of online arbitration was not only the need to avoid a cardiac arrest of international arbitration, the suspension of all international proceedings because of the pandemic. It was also a consequence of it being now feasible technologically. Had the pandemic occurred 15, 20 years ago, it would not have been possible to conduct arbitration proceedings by way of video conferencing. The bandwidth of telecommunication networks simply would not have been sufficient to deal with the data. Despite some initial doubts, and there were quite serious doubts about virtual or video conferenced arbitrations, hearings conducted remotely by video conferencing turned out to be not only a feasible option, but also the more flexible option. It is much easier logistically and cost-wise to organize a virtual hearing than an in-person hearing. Counsel, witnesses, experts, arbitrators do not necessarily need to travel to one location, and they don't need to book hotels for days or weeks. This also makes it possible to organize hearings on shorter notice, and if necessary, far more often than before. There is now an option for singular block 2-3 weeks hearings on the market, shorter, more frequent, and more focused virtual hearings. This is not to say that in-person hearings have become unnecessary or outdated, far from it. Rather, virtual hearings have further enhanced the flexibility of international arbitration. Again, it is not that virtual hearings or online arbitration replace the classical way of conducting international arbitration proceedings. It is rather that the distinction between the two becomes and has become increasingly more blurred. The virtual and the classical are not alternatives. They can be combined in a variety of ways, depending on the circumstances. Perhaps the most important contribution that digitalization has made to international arbitration is the significantly improved ability of counsel and arbitrators to deal with the volume of data, the volume of evidence, and the volume of submissions, the number of pages that you need to deal with, you need to review in order to prepare a case. It is now much easier for counsel and arbitrators to navigate through the submissions and the evidence, to search data, record the results of your own work electronically in the documents that you have reviewed, and to draft. The key contribution of digitalization to international arbitration has therefore been mainly quantitative, significantly increased efficiency. But this is not its only contribution. It has also improved the quality of written advocacy in the sense that electronic submissions and access to electronic databases and tools such as co-authoring allow law firms to produce better researched and more comprehensive and sophisticated submissions, written submissions. Digitalization has also made international arbitration, at least potentially, more democratic. It is now easier and much less costly for smaller firms and firms based outside the key Western jurisdictions to get access to key legal authorities through online databases. A law firm no longer needs to have a massive physical library to be able to conduct legal research or to have physical access to a physical library in the same neighborhood or vicinity. They can access the same databases, even the smaller firms, databases accessed by Western firms, and often at a cost that is a fraction of the cost required to create a comprehensive physical library. In this sense, the impact of digitalization has not only been quantitative, improved efficiency, it has also been qualitative. But there are also things that digitalization has not changed and cannot change. And one of those is oral advocacy. Oral argument is still done by lawyers, not by computers, and it continues to be as important as ever, if not more important. It has perhaps become even more important because since given the great volume of evidence and greater length of submissions, Counsel continue to play the very important role of not only arguing the case, making their case, but also walking the tribunal through the evidence, the key evidence, and demonstrating how the evidence supports their case. The same applies to cross-examination. Cross-examination skills have also become perhaps even more important than before, and precisely because of the increase in the volume of evidence and submissions. If cross-examination is not well prepared, there's a risk of drowning the tribunal with evidence rather than helping the tribunal to navigate the evidence. Oral advocacy and cross-examination in a digital environment do require IT skills, some IT skills, but they are the skills of a user and not the skills of a developer. Apart from oral advocacy, another aspect of international arbitration that has been significantly affected by digitalization is arbitral decision-making. Digitalization has enhanced the efficiency of arbitral decision-making in a sense, but it has not changed its substance. It has not changed the fact that arbitral decision-making continues to require exercise of judgment, and exercise of judgment in complex disputes can never be fully digitized. And why is this? This is because exercise of judgment in complex disputes is not only about establishing the facts and the law, and then first establishing the facts and then applying the applicable law to the established facts. This is how arbitral decision-making can be presented retroactively, and that's how it's often presented retroactively, but this is not how it works in practice. Exercise of judgment is not a linear operation. It does not proceed smoothly like an algorithm from point A to point B and then to see the output. The law and the facts, the A and the B, are not a given. They need to be identified and established in the course of the decision-making process. In this sense, they are produced during the decision-making process rather than found as something pre-existing. The law and the facts are not pre-existing the arbitration. Digitalization, therefore, can only take us so far. It can never replace the process of qualification, the characterization of facts and the law, characterization of facts as facts and the law as law. One cannot compute something that does not yet exist, something that is only produced in the course of the decision-making process. Thank you very much for your attention.